Good morning. Can you hear me? Can you hear me? I can't believe it's September already. Where has the year gone? So, I wonder if her new lawyer. Who's that? Is that her new lawyer? It's so crazy that she got a lawyer from that ad. Stupid cat. She's like, that's my room, and you keep closing my door. You can't see my Star Wars poster with the door closed. Oh, and I turned the sound off in court. Don't stare at me like that. You were just in there. You didn't do everything you had to do. That's on you. She's so funny. She's like, that's my room, and you keep closing my door. So after the hearing, I'll go over his notice to appear and the motion for continuance. Well, I might not have to, because that motion for continuance is probably going to be addressed. Now what? Come on, get it together. I don't think he will. I don't want him to. Because I'm already like, what am I going to do till October 7th? I'm addicted to live streaming now. I even bought, well, I didn't buy it. My husband bought it for me, an Ethernet cable. So I'm hardwired in now. I'm ready to go. Just, we have to pray and cross our fingers that none of my pets snag this cable, because it's 25 feet long and it goes all the way to the other side of the house. I don't think he'll grant it, because he was adamant about, you will not get any more continuances. And I don't think he's going to go back on that. He is not happy with her behavior. And I don't think he was very happy with the ad that she put at the end of the letter. And I don't think he was, like, she was digging, you know? Like, every time she'd be like, I've been forced to go pro se. And I don't think he liked that attitude. Like, of course he didn't say it, but I don't think he liked her attitude. I know if I was a judge, I wouldn't have liked her attitude, because it was her fault that she was forced to go pro se, because her behavior. And I was watching her interrogation yesterday, and she's like, "So what happens now? What's the timeline?" And the detective was like, "I don't work at the jail. I don't know what happens next. I don't know the timeline." And I was like, 4 years later, because of her behavior. This could have already gone to trial. Well, Peter, did you watch Peter's video? Because Peter said that he thinks that Judge Cranick could allow a short continuance, like a week or so, but then also tell this attorney, you cannot withdraw. I would love to know what's going on. Oh, yay, we get to look at our seal. Indians. Yay. You know that the Seminole Indians were not actually the first Indians in Florida. And there went the ADHD. So Peter said that, dang, why was I never diagnosed with that? Because I dang sure got it. So Peter said that if Cranick allows a short continuance, that he will probably tell the lawyer, you cannot withdraw. Because if he asks for a continuance and then Sarah starts to do the same kind of crap that she's done in the past, and then he goes to withdraw, then there's going to be another delay. So that's something that the judge can do to remedy that, which makes perfect sense. So either he gets a continuance and is not allowed to withdraw, or he just doesn't get a continuance. I don't know how long the trial. Yeah, because he said it started off, it was just going to be like a 5-day trial, which shocked me because Cashman said that she only needed 5 days. Like it was going to be like a 5-day trial when Cashman was on it. And then he extended it to 3 weeks when Sarah was going to be pro se. So with a lawyer now, yeah. So now how long is it going to be? Does it go back to 5 days? Or is it still, I don't think he needs 3 weeks. I mean, I know she's innocent until proven guilty, but she put the man in a suitcase. I mean, nobody else was there. She put him in a suitcase and went upstairs and went to bed. And there's video evidence of him begging her to let him out of the suitcase. So how are they going to drag it out? I mean, I get the battered. Oh, wait. I can't even talk this morning. Battered spouse. Battered spouse. And then people are like, well, they're not married. And doesn't matter. Living together, it's the same principle. The battered spouse, battered wife thing, whatever it's called. Like, I get that as a defense. But when he's begging you to let him out because he can't breathe, does battered wife still cover that? Because, like, Peter was saying something about depraved heart. I need to look that up. I think that's a Florida thing. Because if someone's begging you for their life, does that still fall under? I don't know. Do you? I know you don't remember. You weren't even born yet. Back in, I want to say the 80s. I remember watching this movie with my mother. I have been a true crime fan since probably since the 80s. My mom loved the first R-rated movie. No. The first R-rated movie I ever saw was The Amityville Horror. And I went to see that with my mother because it was based on a true story. My mom, National Enquirer, anything crazy, kooky, weird, my mom loved it, which is probably why I am the way I am. And there was a movie back in the 80s. Farrah Fawcett was in it. If you don't know who she was, she used to be one of Charlie's Angels back in the 70s. She's real popular back then. She died the same day Michael Jackson did of cancer. And this movie was based on, which you may know the court case because of, every court case that ever happened for some reason at your young age. It was a battered wife who actually, the movie was called the movie was called The Burning Bed. She lit her husband's bed on fire and burned him to death in the bed, and she got off because of battered spouse. Like, that's one of the very, very first cases of it. But stand your ground. That's when somebody is like a home invasion, when someone comes into your house. Stand your ground that you can shoot an intruder in your house. So he wasn't an intruder in her house. He lived there. So, and I don't know that much about battered. Why am I having trouble saying the word battered? Is it sounding right? It's sounding wrong to me. Battered spouse. I don't know. It just isn't sounding right. I don't know. Like, I guess. See, okay,
qualify for representation by the Public Defender's Office in this matter. Can I get appearances, please?
Yes, Judge. Samantha Smith, and at this time will enter a plea of not guilty, waiver reading the charges, and reserve filing.
Okay. All right, sir, I'm going to give you 2 dates. You don't need to memorize these. You'll be given paperwork momentarily. The first date is the date of your pretrial conference. That's where we're going to discuss whether or not your case is ready to proceed to trial. That will take place on November 22nd at 1:30 in the afternoon. And if your case is ready to proceed to trial, it may be tried during the 2-week trial period beginning December 9th at 9 a.m. Before you leave here today, make sure you give all your contact communication information to your attorney to your right, and I wish you the best of luck, sir.
Oh, that's a different case. It's just the tail end of a different case, I think. Hey, Maribel! I've been worried about you. You disappeared. Hey. Okay, I forgot what I was saying. What was I talking about? Oh, the battered spouse. Back in 2018, they were both arrested because she fought back. She strangled him when he kicked her in the eye, drug her upstairs, kicked her in the eye, and she strangled him. He said he had to kick her because he was being strangled. And they both got arrested, but then her charges were dropped. So when does battered spouse syndrome apply? If you can't fight back and defend yourself, when does battered spouse apply? They both got arrested. I don't understand. If you just out of the blue kill them when nothing's going on, that's when battered spouse applies. See, I don't know. I need to look into the whole. I'm almost afraid to Google stuff anymore because Google searches are always checked. However, my Google searches are probably already horrendous because of all the true crime stuff I look up. But I don't know, like the fact that she recorded it with him begging, I think that kind of screws up the battered spouse thing. I don't know enough about it. Hopefully there'll be an expert. Hopefully she'll get an expert that can explain it, whether it applies to her case or not, and then I'll be able to understand it. Because true crime people have some. Yeah, true crime people have some gruesome searches, I'm sure. Hey, good morning. Yeah, it did. That was a good movie. It was a TV movie. It's made for TV. Back before all this streaming and everything. I don't know. Maybe networks still do it. I don't have regular TV anymore. I just stream everything. They used to have a lot of really good made-for-TV movies like that, based on true stories like that. I guess they figured people wouldn't pay to go see one, but they put them on TV all the time. And that was a really, really good movie. But yeah, my mom and I watched stuff like that. Oh, good. I haven't read the motion. Like, Peter went over it, but when I'm watching somebody's video and reading chat and everything at the same time, I don't catch it all until I go to read it myself. So I was gonna go over it after this, but I might not have to if they talk about it enough in the hearing. Yeah, that's what I was wondering. Because he's begging her. And she's just sitting there taunting him. Yeah, that's my name. Don't wear it out. Like, I don't think you can say that you did it because you were battered when you do that. Because that whole thing seems like revenge, not protecting yourself. Like I said, I don't know enough about that defense. Oh, she's all happy and giddy today. She's not pro se anymore.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning, pleasure.
Oh,
Good morning.
look at that
Could you please
smile.
state your, raise your right hand now, first, and go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Yes.
I'll be right back.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good.
I thought they were doing that today.
Did it take place between the state, yourself, and was Mr. Lang with Prison Break Investigations?
Now I gotta get premium YouTube, I guess. Any day now. Good Lord.
File yet? I did not see them this morning. I did see the motion to dismiss.
Can I post them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to
Morning, sir.
the hearing.
Thank you.
The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the column number 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the others aren't.
This is what it is.
They were all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday,
Yes,
and I've spoken with Dr. Brooklyn 2 or 3 times this weekend.
Fine. Let all you
The state was able
dirty
to provide
laundry.
me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Brooklyn. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both.
Right?
With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state of you the opportunity to review this.
He and Sarah are going to get along great. He's doing a Sarah Boone.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we had to prepare to make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the
Look at that smug smile on her face. She is so happy she can't stand it.
motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, state, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone manufacturing defense. And there's a second doctor, Dr. Michael Brandon. I don't spell that right, sir. Dr. Michael Brandon.
R-A-N-N-E-N?
He spells it Brannon. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brannon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brannon said victims of repeat violence may fear death in situations others would not.
And
I've tried to reach out to Mr. Brannon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brannon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making, that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence in these 2. We're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
the JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs. They've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Rhodes.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. But it is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a better spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew in the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim, and I respectfully ask. I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year.
No.
I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and
Don't
formulate
do
their
it.
opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried. We have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
You should have said that.
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within.
Yeah, Mirabelle. She has a lawyer now. Do you remember that ad that she wrote up all nice and pretty with the different fonts and sizes and, you know, like become famous or show your talents and whatever? Somebody responded one night, like at late, like at 10:30. A lawyer showed up at the jail and she wouldn't see him. She's like, I don't have a lawyer. And like she went back to sleep. And it ended up it was this guy. And he's seen her like 4 or 5 times now. And he put in on the 30th, he put in his notice to appear and at the same time put in this motion for a continuance. Just like out of the blue. And we were like, what? It went fast. All of a sudden she went from complaining, I'm being forced to be pro se, to she has a lawyer now. And everybody was shocked. It happened so fast. It was so crazy.
30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, I'm going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No,
All right, thank you very much. All right, Mr. Oates, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue, you met with Ms. Boone on 4 different occasions. You just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, have such extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a category A witness list, disclosing Ms. Dr. Harper as a testifying expert. And as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times
It'll still be the same.
appointed once by Attorney Bankowitz,
Dr. Jury specializes in battered wife or battered spouse syndrome. Once by Dr. Benkowitz Mr. Benkowitz, on July 17, 2023 again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State 221 Southern 3rd 562 at 569, there's a two-part test determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and have the opportunity to review those.
I get compliments anytime I wear this. I think the shade is just so stunning, especially for fall or any.
Based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the matter of spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in the State 311 Southern 3rd 185 and 189, Florida 2nd DC 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got Dr. Day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I have 12 clients that are pending. I've got other people covered, but I do have a full document. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. And I went to the jail yesterday. I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone. to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what.
Yeah, if Wooten was still the judge, he would have probably gotten his continuance. I'm glad they switched judges. Because Kranick he's over it. He wants this over and done with.
I assume it's being redacted. I know some of the audio in terms of clients' comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Give me a moment.
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigations shall follow with court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go by jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial. whatever that is, a week prior to that Monday, October the 7th, the week prior.
No, he's not asking for a continuance. He's not asking for more time. There's a deadline about looking at digital evidence and making objections as to what goes into the trial and what doesn't. And he's missed that deadline by coming on at this point in the trial. So it's too late for him to make objections about what comes in and what doesn't of the digital evidence. And he's not looked at all of it yet. So he just wants the deadline date moved a little bit so that he has time to look at everything and object to what he wants to object to. So it's still going to start on October 7th. So he's not asking, it is more time, but it isn't at the same time. You know what I mean? Like, he just wants that deadline just nudged a little bit so he has time to object to what he needs to object to. So I think that's okay.
Steve?
I'm going to be amenable to setting a status hearing that week.
Here's what we're gonna do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
That's
State anything else?
not this time, Your Honor.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Is that it? Yep, I think that's it. Okay. Yeah, he's in Milton, Florida. I swear, I'm gonna fight with this cat over this door. She's staring at me from the other side of the room. Like, don't you shut my door again. I was gonna show y'all his motion to appear. I don't have it pulled up. Let me grab it real quick. My orange clerk. I like the Manatee County one. Oh, this one's doing it now too. I was going to say I like Manatee County because I don't have to type anymore. I just click it and Ashley Benefield's name pops up. But now the Orange County one's doing the same thing with Sarah Boone. Before it was I had to retype her name every time. But now it's doing it for me. Yay. Yeah, he's in Milton, Florida. And which I don't know where Milton is. And we have an airport in Gainesville. It's a very small airport. It's not like an international airport or anything like that. It's a teeny tiny airport. So here is Can you guys see that? Oh, I need to make the font bigger. Okay. Notice is hereby given that James Owens hereby enters his appearance as counsel on behalf of the defendant, Sarah Boone, in the above style case. I now certify that I electronically filed the proceeding with the clerk of courts by using the e-portal system. James Owens. Milton, Florida. I have no idea where. I can Google it. Where is Milton, Florida? There's a Baghdad, Florida. Santa Rosa County. I didn't even know we had a Santa Rosa County. Pace to the west and the. Oh, it's near Pensacola. It's in the Panhandle. Okay, it's in the Panhandle. Yeah. So notice of appearance. And this. Oh, dang it. I thought it made it bigger. Oh. Dang it. Wrong screen. I made the wrong screen too big. I made the StreamYard screen too big. Now your chats are huge. Okay, here we go. Defense motion for continuance. Comes now the defendant by and through the undersigned attorney under Rule 3.190 of the Florida Rules of Criminal Procedure and requests this court to grant a continuance of the 3-week jury trial set for to begin October 7th, 2024, and alleges it still says 3 weeks. Did they say? I don't remember hearing them say it was going to be shorter than 3 weeks. The defendant is set for trial by jury on October 7, 2024. The defendant has just retained defense counsel and a notice of appearance was filed on Friday, August 30th, 2024. 38 days remain before trial. Defense counsel has met with the defendant 4 times at the Orange County Jail, August 20th, August 21st, August 26th, and August 27th. During these meetings, the defendant disclosed the potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered. Why am I having trouble with that word today? Battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time not only for administering appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship, and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemented with historical and documentary information from third parties. And she would have had time to do that if she behaved herself. This process, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. Notice of intent to rely on the battered spouse syndrome defense must be filed 30 days before trial. The notice must be filed by September 7th, 8 days away. The defendant has been deemed indigent for cost. The defense will need government funds to assist in paying the experts in this field. Defense motions will need to be filed concerning the potential Brady material. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28, 2024. The defense counsel responded to her advertisement and was retained. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. The defense certifies this motion is made in good faith. Memorandum of Law. The Sixth Amendment to the U.S. Constitution guarantees that any person brought to criminal prosecution in a federal court must be afforded the right to the assistance of counsel for his defense. I don't want to read this whole thing. That's just the most important part, but it's just the Bill of Rights part, the Sixth Amendment. Wherefore, the defense would respectfully request the court consider this request and grant the defense motion to continue. James Owens, counsel for Sarah Boone. So yeah, she has a lawyer. Yeah, he didn't say anything about it, so yeah, that did seem like a Sarah Boone thing to do. Stupid phone. Yeah, and he may, I felt bad that she didn't have a lawyer, even though she is the way she is, because and I've seen the videos. I have an opinion. I know she's innocent until proven guilty, but I have an opinion. I've seen the videos of George in the suitcase, but she still needs to be represented by a lawyer. I cannot imagine. And I also believe that she did not intend for him to die. I do believe it was unintentional. That doesn't mean that you don't suffer the consequences of what you did. It's still, somebody's dead. You killed someone. But you still need to be represented by a lawyer. I can't imagine having to pick a jury. Like, I wouldn't know how to pick a jury. I wouldn't know, I wouldn't know what questions to ask and know who to strike and who to keep. And I wouldn't know what questions to ask witnesses. I wouldn't know who to call in my defense. I wouldn't know anything, so I'm glad she has an attorney now. It would have probably been more fun if she hadn't, but then everybody needs, yeah, Daryl Books did it. He also he started off with representation and he had notes and stuff from his lawyers, but, I guess she did too. if she kept anything that the lawyers did. I guess in that discovery, maybe there was like notes from her lawyers and stuff. But everybody needs to be defended by a lawyer. And yeah, she's indigent, but maybe he was one of these people that, like me, that thought, well, she needs a lawyer. You know, she can't do this by herself. And she could have paid him $1, you know, like, or he could be doing it pro bono. Who knows? He might be one of those lawyers that makes enough money that he just took this case out of the goodness of his heart. You know, or he might have just said, give me $1. Because some people do that, like, it's like pro bono, but, you know, to make it like official, like I've been retained, they give them $1 or, you know, a very small amount. So, oh, Kranick did say he was pro bono? Oh, I missed that. So I'm glad she has a competent lawyer. I still don't see how she's gonna, like I said, I'm anxious to hear the battered spouse expert because I don't get it. If you're being battered and then you use self-defense against your batterer, then they come and arrest both of you. So battered wife doesn't apply in that instance. So I need a battered spouse expert. I need to know what the definition of it is and all that stuff. Well, yeah, she did. She was writing motions, but Peter said that what they do when they, you know, people that do their own motions like that, they go to like the law library in the jail and they just copy stuff out of books. That's why, remember when she wrote the motion about being unshackled? She didn't really mean being unshackled. She just wanted to be unhandcuffed. But she wrote the whole thing as being unshackled. So then when the judge was asking her questions about it, she was like, well, I meant I wanted to be unhandcuffed, but I do want to be unshackled too. Like it was this big confusing thing because she didn't realize what she was writing. And Peter said that's common because they just take out these law books and they just copy what it says. That I don't know, but Kranick was talking about, you know, because I wrote it down. Because he talked to, what just happened? Oh, cool. I accidentally hit the space bar and that disappeared. Good to know. He asked for a death investigator, a crime scene reconstructionist, and a forensic psychologist. And Kranick said that he would have the court clerk, reach out to JAC. So I guess JAC will pay for those things. Which seems kind of strange. Because he's not a public defender. He's pro bono. I would think he would have to pay for that. I don't know. Didn't he say something about a hearing on September 10th? Like pre-trial is September 26th at 9 a.m. I got that. But then I thought he said something about a hearing on September 10th. But like a possible hearing. So I put a question mark by it, but then I didn't hear him say anything else about it. Oh, wow. That's cool. Yeah, I mean, lawyers make oodles of money. There's nothing wrong with them doing something nice for somebody needy. Possible. Very possible. Because she hasn't even gone to trial yet, and I hate saying stuff. I mean, we've all seen the videos and her interrogation, but yeah. Very possible. Yeah, but the thing is, I don't think they were going to let her pick who she wanted and pay what they wanted to be paid. I think that, seriously, you are not the boss of me, little girl. You're not. We're going to fight. Oh, are we going to fight over that door? Seriously? All right, I'll open your door. Good Lord, stubborn cat. Yeah, I don't think she was allowed to get just, because different experts charge different rates. Well, are you going to go in there? At least they can't see the litter box. No, she just wants her door open. You're rotten. Yeah, I'll keep checking the docket. He did say something about September 10th, but then he never said anything else again, so. Yeah, her money's definitely limited. Okay, guys. I will let y'all go, and I'm working on my Sarah Boone episode that I'm going to have up sometime this week so that everybody is all caught up about Sarah Boone before the trial starts. So keep a lookout for that, and don't forget to like and subscribe and share and all that good stuff. Because like 90% of my viewers are not subscribed, and I don't understand why. Oh yeah, that would have gone over really well. Okay, guys, thank you for watching with me, and I will see you guys later. Love y'all. Have a good day. Bye.